Good afternoon. It's a great pleasure to see you all here this afternoon. For those who don't know, my name is Brendan Plant. I'm a fellow at Downing College, Cambridge. And the first thing I'm delighted to announce is that spring has sprung. It seems that way. If I think we might have learnt in the past that we're tempting fate to embrace warmer climes, it might very well turn next week. My second order of business is even more delightful, and it's a very great pleasure to welcome to the centre this afternoon Hussein Haeri KC. Hussein has a very accomplished practice in international law. He is, of course, a fellow partner of the Lauterpacht Centre, and we're very happy and lucky to have Hussein's association with the centre. He has a wide-ranging practice as the head of the Public International Law Group at Withers LLP, based in London. His experience traverses all manner of areas of international dispute settlement, cases before the ICJ and ITLOS, arbitrations under ICSID and UNCITRAL rules, and of course, a vigorous practice before international courts and in advisory matters as well. He's going to speak with us this afternoon for about 45 minutes or so, that I'm not going to hold him to it, on recent developments concerning state immunity, and we'll keep time at the end then for a Q&A discussion, which I'm sure Hussein will be more than happy to field your questions. So without further ado, allow me to introduce and welcome Hussein Haeri KC.
Thank you very much, Brendan, for the kind introduction. Thank you, Professor Sivakumaran, also for the invitation. And I'm very glad to be here at the Lauterpacht Centre to be discussing the issue of state immunity. State as compared with immunity for individuals, or diplomatic immunities which fall outside the scope of this lecture. Also outside the scope of the lecture are distinct but related concepts such as active state doctrine and non-justiciability. So what is conceptually state immunity? Well, one meaning of the term immunity, at least in medical terms, is the quality of being resistant to a particular infectious disease. And the dis-ease in this context is that of a state being subject to the adjudicative jurisdiction of another state's courts, or to having its assets enforced against through judicial decisions of another state's courts. That's the disease from which immunity is sought. Immunity, essentially, as a general rule in customary international law, is that a state, absent consent, is immune in two respects. The first is an immunity from the jurisdiction, the adjudicative jurisdiction of another state's courts. They shouldn't have jurisdiction to determine matters with that state, absent consent. And secondly, there is an immunity from execution in another state against the assets of the former state. So those are the two elements of immunity, and it's a requirement in customary international law that they are upheld and respected. The conceptual underpinning for immunity in international law is, of course, the independence and sovereign equality of states in the international legal system. And this can be reflected in the Latin maxim, for example, par in parem, non habet imperium. It's associated with the Westphalian system of independent sovereign states that emerged following the Peace of Westphalia in 1648. And in this sense, it might be said also to be associated with legal theories of positivism. It is also reflected prominently in the United Nations Charter, and in particular in Article 2.1 of the UN Charter, which provides that membership of the UN is based on the sovereign equality of all of its members. So this issue of equality is the theoretical and legal underpinning for the issue of immunity. However, there is another important international principle that weighs up in a different manner with regards to the potential exposure of states in the courts of another state. And that is the principle of territorial jurisdiction, also an important feature of the Westphalian system. And that principle can sometimes incline away from immunity. If a state is carrying out, for example, commercial activities, if it has commercial assets in the territory of another state, should it not also then be subject to the ordinary rule of law and procedure of litigation in that latter state's courts, particularly when it is engaging as a commercial party, as a merchant, as the historic term was known. And so this tension, if you like, or dialectic perhaps, between the principle of, on the one hand, equality, which inclines towards immunity, and the principle of territorial jurisdiction, which can incline away from immunity towards a more restrictive version of immunity, a more qualified version of immunity, is reflected in the cases that address these issues in national courts. And the point that I will be looking to address in this lecture is the way in which, certainly over a long period of time, but then also more recently with developments, you can see some inclining towards territoriality in the sense of an increasing tendency in laws and by courts towards accepting some restrictions on immunity away from the more absolute concept. And that essentially is the main paradigms, namely that of absolute immunity, that immunity applies without any meaningful qualification, and what's called a restrictive doctrine of immunity, which says that in certain circumstances, usually of commerciality, for example, immunity may not apply, particularly execution immunity in that context. And one of the reasons I would suggest that you increasingly have this tendency towards a more restrictive approach to immunity is the connectedness of and extent of interaction of states in commercial activities. And we'll come on to talk about that in terms of not just sovereign wealth funds, but more generally state-owned entities and the interconnectedness that has arisen through globalization, particularly over the last decades, notwithstanding perhaps very much more recent developments in that respect. So that's one of the reasons for the inclination towards a more qualified approach to immunity. And that connectedness of states in other states is also reflected in other areas, though, not just the commercial aspect. For example, we've got in this jurisdiction recent decisions that have upheld claims and have not accepted immunity as a basis to preclude jurisdiction for matters relating to torts that have had effect in this country, even though they took place outside of England. That's the Shahabi case against Bahrain in the Court of Appeal recently, and also in the area of employment relations. And we know that from the Lorenzo case against Spain, but also just last night, the decision of the Supreme Court in the Constantine case with Saudi Arabia. So in all three of those cases, you see limitation on immunity being applied in those contexts where there is a territorial nexus. Maybe the tortious effect happens here, maybe the employment activity happens here. And so those are also, I would suggest, part of the increasing inclination in different contexts of states to accept jurisdiction and not to uphold immunity as a bar to it. Now, the issue of balancing in this way can be looked at in another manner. The question of identity, who are you, does incline towards the exceptionalism of state immunity. States are the primary subjects, the primary actors, and when one looks at that test, then immunity would usually follow. You see that, for example, with regards to central banks, and very often legislation protects central banks, even for assets that they have or activities that might otherwise be considered as commercial. So their identity informs the extent of immunity. But of course, there's another question to who are you that moves in another direction, and that is, what are you doing? And what are you doing can incline towards a more restrictive approach to immunity if what you are doing, for example, is essentially commercial. Now, taking a step back on that aspect, just to consider the importance of state involvement in commercial activity, it's not merely a sort of good point of principle. state-owned enterprises own, according to the IMF, some $45 trillion worth of assets worldwide. That is about half of global GDP. Sovereign wealth funds alone own some $10 trillion worth of assets worldwide. Some 8% of listed equities around the world are owned by sovereign wealth funds, including 1% by just one sovereign wealth fund, the Norwegian fund. So the nature of immunity and whether states and state-owned entities have immunity and in what ways has great relevance for international trade and investment, as well as the more general framework of public international law. So in terms of the genesis of the restrictive approach to immunity, in fact, it's in civil law jurisdictions such as Italy, Belgium, and Egypt that we see the early antecedent cases most prominently, in which there's a distinction made between a state acting as a sovereign authority or acting in a private law capacity. And so from the 19th century, for example, we see in Italy cases where the courts have differentiated between what they call atti impero, for which immunity applies, as compared with atti di gestione, for which immunity does not apply. The public nature of the state act in these cases is the determining criterion for whether immunity would apply or not. And so we see here the genesis of what later emerged into the qualified doctrine of immunity that limits immunity in circumstances of commercial activity by states. Now, this rather progressive approach taken by the Italian courts from that period, allowing individuals potentially to bring successful claims against states, has gotten a more recent manifestation, if you like, in the ICJ jurisdictional immunities case between Italy and Germany in 2012, to which I will return. Similarly, the Belgian courts showed an unusual consistency of approach going back to the mid and late 19th century of restricting immunity in circumstances where states were acting in essentially a commercial capacity. And we can see that going right back to 1857, for example, where in a trio of cases involving Peru and the Guamo monopoly there, the Court of Appeals of Brussels distinguished commercial activity for which immunity didn't apply as compared with public actions for which immunity would. Notably, also of interest, I believe, the mixed courts of Egypt, which were the highest courts in that jurisdiction from 1875 until 1949, adopted this distinction between public and private acts. And in fact, one can see in 1894 that an Egyptian mixed court upheld the claim by an English national who had had a concession for the tramways to construct the tramway system in Cairo, and the courts said that that claim could proceed, and immunity was said not to apply because it was determined that this was a commercial concession and therefore not a matter of public sovereignty, as it was put in that case. So we have these antecedent limitations on immunity in the civil law jurisdictions. And so what of the position in the common law world, as it were? Well, by contrast, in common law jurisdictions, historically, there was an approach of absolute immunity that was usually, if not consistently, applied. In other words, that whatever a state did, the courts of another state ought not to take jurisdiction over it, nor enforce against the former state's assets. Now, this absolute approach to immunity developed essentially out of the separate immunities that applied to heads of state, to ambassadors, and to warships. And a very notable early case that reflects this approach is the schooner in 1812 in the US Supreme Court. So this was a ship owned privately by US nationals that sailed and stopped in Spain. There, it was seized by an executive order of Napoleon Bonaparte and turned into a French warship. It later docked in Philadelphia in the context of a storm, and legal proceedings were brought by the former owners who claimed that it had been unlawfully seized and therefore ought to be returned to them. The US Supreme Court disagreed, and Chief Justice Marshall delivered the opinion of the Supreme Court that France had immunity from suit. However, he did also note, and this is an important point that gets picked up in later arguments about qualified immunity, he noted that where individuals and merchant vessels enter for the purposes of trade, it would be obviously inconvenient and dangerous to society and would subject the laws to continual infraction and the government to degradation if such individuals or merchants were not amenable to the jurisdiction of the country. So here we have early ideas that then later culminate in a restrictive approach to immunity in certain commercial circumstances. Now, in England, an absolute doctrine of state immunity was reflected in the Parlement Belge case of 1878. And in this case, the privileges and immunities of diplomat and sovereign were essentially extended to the state, to state immunity. In this case, there had been a collision of vessels. One of the vessels was owned by the King of Belgium, but it was engaging in postal and other trading activities. Notwithstanding that, immunity was upheld by the courts. And so for some 50 years thereafter, essentially this absolute approach to immunity was followed for states in this jurisdiction. It's not until the watershed case of Trentex and the Nigerian Central Bank in 1977 that we see a real pushback on that. And of course, it was a watershed decision, Lord Justice Rodeni being on that Court of Appeal at the time. And essentially what happened is that the Central Bank of Nigeria had been structured as a separate entity. And so the court found that it was not a department of Nigeria, it was not part of the Nigerian Federation, it was a separate entity. Nor the court said, was it an alter ego? And so the question was, since it was a separate entity, was what it was doing essentially commercial? And if it was essentially commercial, then the court said it ought not to benefit from immunity. Well, what the Bank of Nigeria, the central bank, was doing was paying under letters of credit for the sale of cement from the Swiss company Trentex. And so the court said, well, that doesn't benefit from immunity. But the pushback, if you like, generally that took place with regards to the absolute approach to immunity was more in the context of cases in rem against property that was said to be owned by the state, usually, rather than against the jurisdiction when the state was itself a party to the action. Here, of course, it was different because it was a separate entity. It wasn't the state that was a party. But by the time of Trentex, developments in other jurisdictions had rather moved on. So, we've had since, for example, 1952 in the US, the Tate letter, and in that letter, essentially the State Department decided to take a different approach, a qualified, restrictive approach to immunity as compared with the absolute approach in circumstances where a foreign state had requested a grant of sovereign immunity. And that restrictive approach in the US from 1952 was then followed in 1976 with the Foreign Sovereign Immunities Act. So that set out a statutory code in the United States of qualified immunity rather than the absolute immunity that had historically prevailed in the United States by and large. It was 2 years later in 1978 that the State Immunity Act was passed for this jurisdiction, and it took that same approach, essentially a restrictive approach to immunity. Now, this legislation was enacted in part so as to enable the UK to ratify the European Convention on State Immunity in 1972, but its implications go far, far beyond that, because it's proved to be a model for sovereign immunity legislation in many other Commonwealth jurisdictions, and that includes Canada, Australia, South Africa, Singapore, and Pakistan, to name a few. The State Immunity Act draws a distinction between adjudicative immunity, so that's immunity from suit, from being sued in another state's court, and execution immunity, that is immunity or protection from a state's assets being enforced against. The default position under the State Immunity Act, or the SIA, is that a state enjoys both immunities. from suit and from execution unless an exception applies. Now, when you have an absolute doctrine of immunity, everyone knows where they stand. The state is immune. Where you have a qualified approach, it becomes much more complex. Where exactly does the line get drawn? The drafters of legislation may think they've drawn it very clearly, but the history of litigation suggests otherwise. And in fact, that's indeed what has happened with an increasing number of cases in the English courts addressing exactly where that line is in respective contexts and circumstances, some of which I'll come on to address. Now, as far as adjudicative immunity is concerned, there are a variety of exceptions, and that includes where a state has submitted to the jurisdiction of the English courts, submission being an aspect of consent, consent being a feature of state sovereignty. And one can see in another context, for example, going back to limitations on state action through agreement, through consent, that is an inherent feature of sovereignty. One can think, for example, of the Permanent Court of International Justice case of the SS Wimbledon, going back to 1923, albeit in a different context. So if a state consents to go to the jurisdiction, or they agree, then that is an exception for it. Another important exception is in the context of arbitration. Where a state has agreed to arbitration, depending on the terms, that is usually taken to be a waiver of immunity from suit, at least as far as the arbitration is concerned. And of course, when it comes to the national legal system, related to that is the arbitration exception, which you have, for example, in the State Immunity Act, also for recognition and enforcement proceedings pertaining to that arbitration. And so that's another exception to adjudicative immunity, at least as far as the recognition of the arbitral award is ordinarily concerned. But that doesn't mean that the exceptionalism of the state as an actor has no role or relevance, because it does, even here. Consider, for instance, the practically important issue of service. A state has more time to respond to service in the context of recognition of an arbitration award in this jurisdiction. And the nature of service is completely different, of course, with regards to states. That is usually through diplomatic processes, unless there's a clear agreement to a different route, and that takes significant time and introduces significant complexity. Also inherent in the exceptionalism, if you like, of states in this context is that they cannot be subject to anti-suit injunctions, and they cannot be subject to contempt of court proceedings. But there are some limits to that exceptionalism, and this played out in a case in which I am involved for a company called Zhongshan in the context of an investment treaty arbitration award that it had rendered in its favor against Nigeria, seated in this jurisdiction. It was not an ICSID case, it was an investment treaty tribunal under a bilateral investment treaty, and the award rendered in Zhongshan's favor had been chaired by Lord Neuberger. And as part of the recognition steps that were then taken by Zhongshan, there was a High Court order that was obtained on an ex parte basis, as is usual in the first instance, before notice and service and a return date to potentially challenge that order, recognizing the arbitration award. And what happened next is that Nigeria missed the deadline to challenge the recognition order, and out of time, essentially argued that what was required of the High Court judge considering the recognition was to have looked at the underlying file pertaining to the arbitration to convince herself that an exception to immunity applied in the absence of Nigeria meeting the timing requirements for it to take that point or make its arguments itself. And this was going too far in terms of exceptionalism, both for the High Court, but then also for the Court of Appeal, which decided this case in 2023, where it said that to require the court to go so far would be, in the words of the Court of Appeal, pointless and absurd. So as far as immunity from execution is concerned, however, there are two exceptions The first one is whether the property in question is in use or intended for use for commercial purposes. And the second one is where there is a clear waiver of immunity from execution. But of course, a waiver of immunity from suit is not in itself a waiver of immunity from execution. And we see that in the context of ICSID arbitrations, for example, where we have the provisions in Articles 54 and 55, which very clearly differentiate the one from the other. And similarly, in this jurisdiction, a waiver of immunity from suit would not be a waiver of immunity from execution. And so this is an important point of practice in the context of negotiation and drafting of agreements with states and state entities. Now, the commercial purposes exception, to take the first one, is a fairly high bar in this jurisdiction. And that's not least because a state's ambassador can issue a certificate attesting to the use and intended use of property. And that creates a presumption which can potentially be overcome, but there's already a high threshold in order to do that. And so you can imagine, of course, and you will have seen this in cases, I'm sure as well, that the likely scenario that one faces as a creditor, at least in this context, is a certificate being issued which says that this is not for commercial use or intended use. Now, to make matters more complicated, the UK Supreme Court in the Raffidain Bank case against Servas also said that in use or intended for use in terms of commercial purposes exception doesn't just mean that it's related to a commercial transaction. It has to actually be, the property in question has to actually be in use or intended for commercial use. So the combined effect of those two elements, the certificate and the fact that you actually have to have the property in use or intended for use, does create a high bar. Now, this came up also in the case of enforcing the Zhongshan Award against Nigeria, because there were initial interim charging orders that Zhongshan secured against two properties in Liverpool in the context of enforcing its award. What followed was a certificate issued by the commissioner of the Nigerian embassy and essentially, or their mission, and essentially it said that these were for consular purposes and were not for commercial use. And so that was the presumption that then needed to be overturned. Now, one of the team, who in fact is here today, did a site visit and knocked on the doors of those properties and met the tenants and essentially was told that they were being rented at commercial rates. And so witness evidence was adduced that resulted in the High Court overturning the presumption of non-commerciality and finding that they were indeed for commercial purposes. And as a result, final charging orders were issued. So it is possible, but it is also relatively rare. Now, that commercial exception of sovereign immunity is now prevalent in many countries around the world. It's reflected, for example, in the UN Convention on the Immunities of States and Their Property of 2004, albeit that convention is not yet enforced. It's also reflected in the laws of, for example, France, where there's an exception to immunity where the property is other than for non-commercial public service purposes, which is another way of formulating essentially that if it's for commercial purposes, then immunity doesn't apply. Now, in the Zhongshan case, we were able to avail of that exception in the context of getting conservatory seizures over aircraft from the presidential fleet, two of which were in the process and for sale at the time, so commercial activity essentially. The international direction of travel from absolute to restrictive immunity goes as far as China. Historically, China had an absolute approach to immunity. From the 1st of January 2024, it moved to a restrictive approach, which does allow potentially for enforcement against commercial assets of other states and state entities. That applies also since the beginning of last year to Hong Kong. The other basis on which creditors can seek to enforce against state assets is the exception of consent. Consent to waive execution immunity. Of course, as I said, different from a consent to waiver of adjudicative immunity. Now, this exception was found to apply in the English High Court case of General Dynamics against Libya, since upheld by the Court of Appeal in November of last year. And in that case, there was a contract with General Dynamics. And what was provided for is that the parties agreed to treat the arbitration award that would ensue from any dispute between them as final, binding, and wholly enforceable. And what do the words wholly enforceable mean? Judge Pelling rhetorically asked, if not a waiver of immunity from execution, when the award is already being agreed to be recognized as final and binding. Wholly enforceable must mean something more. And in that context, it was held it must mean a waiver of immunity from execution. And the Court of Appeal agreed. Now, as in that case, most of the consents given for waiver of immunity from execution take place in contracts. But it is possible for a waiver to take place in a treaty. And in fact, that came up as part of Zongshan's enforcement efforts against Nigeria in the BVI High Court, where there was an initial attachment debts owed from a third party to the Nigerian Federation. And what the BVI Court held is that the language of the bilateral investment treaty between China and Nigeria, which provided that each party shall commit to the enforcement of the award, was a waiver of immunity from execution. Looking at the language from the perspective of the Vienna Convention, of the Law and Treaties, and Article 31, the court considered in particular that language in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its object and purpose. And it held, similarly to General Dynamics, that that constituted a waiver of immunity from execution against assets. Now, to come back to theory, it's important to note that state immunity is a procedural rule. It's not a substantive obligation. It's not a matter of substantive law. And that aspect was an important point to come back to the ICJ case of the jurisdictional immunities in Germany and Italy. Here, Germany instituted proceedings against Italy, requesting court to declare that Italy had contravened its obligation to respect Germany's immunity by allowing cases to be brought in the Italian courts by Italian nationals with regards to claims of deportation and other contraventions of international humanitarian law going back to World War II. Germany also claimed that Italy had contravened its obligations to respect Germany's immunity by taking measures with regards to Villa Vigogni, state property of Germany that was in Italy in the context of this matter, and also that Italy had contravened its obligations by recognizing Greek civil court judgments arising out of similar facts. Italy argued in response that what we were dealing with here were jus cogens norms. These were peremptory norms of international law, a point that Germany didn't refute, and that therefore they ought not to be overcome by a defense pertaining to immunity, or in other words, the rights of immunity of Germany that would otherwise have applied didn't apply in this context. But the ICJ said that these two things existed in parallel. They didn't contradict one another, they didn't conflict. Jus cogens is dealing with substantive obligations, whereas immunity is a matter of procedure, and it is a predicate matter that jurisdiction needs to be asserted and shouldn't be if there's an issue of state immunity before consideration or relevance arises as far as the substantive obligations and merits of the matter is concerned. So as a result, Italy's arguments of jus cogens rules had no application, and indeed Italy was held to have contravened its obligation to Germany to respect its immunity in this context. Similarly, on a national level, in Jones and Kingdom of Saudi Arabia in 2006, the House of Lords addressed a claim that the jus cogens prohibition on torture resulted in a disapplication of state immunity that was being claimed by Saudi Arabia. In rejecting that claim, Lord Bingham observed that such a prohibition does not automatically override all other rules of international law. The ICJ has made plain that a breach of a jus cogens norm of international law does not suffice to confer jurisdiction. Now, interestingly, at the time of the Jones litigation, I was involved in a case in the English courts on behalf of the Dutch Central Bank, and similar issues to some extent came up in that case. So what had happened is that the Dutch Central Bank, as a separate state entity, but as the regulator of the financial services industry in the Netherlands, had rejected an application by a company to be registered for financial services activity in the Netherlands. And in that rejection, the Dutch Central Bank had referred to individuals associated with the applicant as being untrustworthy. Now, that rejection was faxed to an office in London, where it was read by several persons. And of course, the defamation claim that they then brought was against a state entity, the Dutch Central Bank, but a separate state entity. And so because of that, there would only have been immunity for the Dutch Central Bank if it was acting in the exercise of sovereign authority under the state immunity framework. And what was argued by the claimants is that because this letter was done maliciously, it couldn't have been done in the exercise of sovereign authority. And the High Court, and it was then confirmed on appeal as well, rejected that claim and made reference, interestingly, to the Jones case, which was, as I say, at the time, finding that in terms of the gravity of the allegations made, if the invocation of a jus cogens rule doesn't override immunity, essentially a fortiori an allegation of malice in the conduct of a state entity would not do so. Now, notably, the European Court of Human Rights has considered whether immunity can give rise to a contravention of Article 6 of the European Convention on Human Rights and the right to essentially a fair trial and a fair hearing, and has found that immunity doesn't necessarily contravene that right. In El Adsani versus the United Kingdom, for example, the ECHR recognized the prohibition on torture as a jus cogens norm, but went on to find, notwithstanding the special character of the prohibition of torture in international law, the court is unable to discern international instruments, judicial authorities, or other materials before it any firm basis for concluding that as a matter of international law, a state no longer enjoys immunity from civil suit in the courts of another country where acts of torture are alleged. Now, as was said by the ICJ in the arrest warrant case, DRC versus Belgium, albeit that's in the context of individual immunities, immunity doesn't mean impunity. That is because, for example, the state may waive its immunity, or the courts of jurisdiction where the actions took place may take jurisdiction, or there may be another international fora that is available. So as a matter of theory, that's absolutely right, of course. As a matter of practice, where accessing fora is often critical as a matter of international adjudication rights and the possibilities that relate to that, of course, there is a material consequence that flows from that. And so that might be said to be one area where theory and practice perhaps have some level of dissonance, something that has been reflected in much of the commentary on this issue. So to conclude, international and national authorities are ad idem that state immunity is an obligation under customary international law on states, and when it applies, states are required to comply with it. What is, however, vigorously contested is the scope of that immunity, and in particular, where you're dealing with a restrictive approach to immunity, the scope in different contexts of where the line is drawn. So there is, I would suggest, something of a tension between the immunity that applies to states as exceptional actors, the sovereign equality of states, and the extent of their commercial engagement internationally in the nexus with territories, which can incline towards, in some cases, waivers of immunity, exceptions to immunity, some of which we've discussed today. These developments moving towards a more restrictive approach of immunity, in other words, limiting the immunity aspect, have been much commented on. They've not escaped the criticism of many commentators, not least from Twale scholars, as bypassing the inherent feature of the sovereign equality of states. Weighed up, on the other hand, in favor of the restrictive approach is the emphasis on territoriality and what flows from that in the manner that we have discussed. In other words, what a state does can matter as much as the fact that it is the state that does it. You might say some orientation away from purely personae towards materiae, if I can take that other context to analogize. Now, this was recognized back in 1873 in the Chartier case in the English High Court of Admiralty, where the court said this: no principle of international law and no decided case and no dictum of juris of which I am aware has gone so far as to authorize a foreign prince to assume the character of a trader where it is for his benefit, and when he incurs an obligation to a private subject to throw off, if I may so speak, his disguise and appear as a sovereign, claiming for his own benefit and to the injury of a private person for the first time all the attributes of his character. 150 years after that statement was given, it remains ever more relevant to the developments that we've seen recently and today. Thank you very much.